Hello and welcome to the Inside Stylist podcast. We are back after a little break. We'll call it a little lockdown break. The first few episodes that I'm going to be putting out fortnightly are going to be downloads they're basically audio taken from interviews that I've done during lockdowns. So some of them are Facebook Lives, some of them are Zoom calls. So the audio quality isn't what you would expect from the Inside Stylist podcast, basically because I'm still learning how to take the audio and record it in the right way. So if you could just bear with me on that. But rest assured, if the content wasn't amazing, I would not be putting these episodes out. The guests I've got coming up in the next few months are really, really great. You will get something from all of them. So if you can just ignore any feedback, any buzzing, that would be great. So we're starting off the first episode with Margaret Haig, who is Head of Copyright Operations at the Intellectual Property Office. Now, this came about because so many people have been talking about the copyright laws and how we can use art within photo shoots, but also the question keeps coming up on, are we allowed to share magazine features that we've shot and styled or written on Instagram? Can we flick through a page and share it? And there was so much conflicting information out there that I thought it was best to go straight to the experts and ask exactly what we are and are not allowed to do. And this episode, it's a long one because it is jam-packed full of information. So without further ado, I hope you enjoy the interview with Margaret Haig. Margaret Haig works at the UK Intellectual Property Office, part of the Department for Business, Energy and Industrial Strategy. She's worked on copyright policy since 2013. Her roles include policy on copyright term and exceptions, including when these arise in trade negotiations. She was recently responsible for completing 3 post-implementation reviews on copyright areas we updated in 2014, and also looks after the interaction between copyright and designs. In addition, Margaret has an operational role which includes managing a licensing scheme for orphan works where the rights holder is unknown or cannot be found, and guidance on areas of copyright called copyright notices. That sounds so grown up. Would you like to explain what that means in kind of general terms?
Sure, and thanks so much for the invitation to speak with you today. I'm really interested to hear what people are asking about and talking about some of these things. So probably the most relevant part of what I do is look after where copyright and designs kind of overlap. So a lot of you will be aware that copyright covers a vast multitude of different things. So there are literary works, books, poetry, but also including things like software, websites. And then there are artistic works, so paintings, photographs, sculptures, engravings, and then you have film works and musical works, and all of these are protected by copyright. And for some of them, particularly artistic works, there's an overlap with what are called design rights. And design rights are quite specific. It's a specific intellectual property right, and there's a registered design right and an unregistered design right. And so there's an interesting interplay between the two of them. So how I look after that, in a sense, is I'm a policy official. So at the Intellectual Property Office, we're not enforcers. We don't go round saying, oh, you shouldn't do that, or, we don't give permission for people to use copyright works, but we try and make sure that the law and guidance is as best as it can be to actually help people work in the real world, basically, just like you and your members. So we deal with broadcasters and filmmakers and musicians and poets and novelists and all of those things, but also artists and designers and the people who your members will be interacting with. Hopefully I can give a bit of context around how it will be for stylists and what the copyright things that they should look out for, some of the sort of tips that I would give to people, what order to look at things in. So those kind of things, hopefully they'll come out in the questions that we have today.
Yeah, do you know what? I think of, from my work point of view, I think of how copyright affects what we do as stylists and as writers. But actually, you've just opened up a whole new section that I hadn't actually thought of. yeah, so kind of people know about quite a lot of elements. I mean, we kind of spoke a little while ago about kind of why I really was interested in having you on. And then I opened it up to the members and said, send me questions that you would specifically like explained. And a lot of them were duplicated, but there were other things as well, and things you've just been talking about. I mean, just when we came on live, you were just saying, I've got a picture in the background, you've got a picture in the background. Obviously, we're not sharing that, but these are the kind of things that when we're shooting could come into it. Mm-hmm. So we've got quite a lot of questions to get through. So I might just go straight into it, because I think everything that we talk about is in these questions. Also, I should say at the beginning that, like you were just saying, you aren't enforcing anything. You aren't going to be able to deal with specific issues. If someone wants to ask a question, by the way, guys, if you want to ask, then please do in the comments. I can see the comments. Then we can look at some things, but we won't be able to go into any specific issues. I have got one question that is about a specific issue, but I'm kind of interested in the overall kind of copyright issue with that issue. So we will ask that, but we won't be able to go into specifics about how to help that person. So without further ado, right, clipboard at the ready. So some of these are things that come up in general, and some of them are specific things that people have come across within styling and writing world. So the first one is, when shooting editorial and commercial photography, which includes art within the rooms, how does the copyright law affect those situations? We've heard about stylists being sued for using art when they don't have the copyright to do so.
Yeah. So this question kind of encapsulates more or less all of what I would want to say to you. So it might take a while to answer it, but that's because I want to give you as much information as I can to help. So when you creating any art, and that's what you're doing, you're creating a photograph in the main, some of you might do sketches as well, I guess, but in the main, we're talking about photography. So when you're creating a photograph, at the beginning of the process, you should be thinking, okay, what do I want to feature in that photograph? There may be works within that. So there may be copyright works that are featured in there. Now, what is protected by copyright? I've mentioned a few of the different kinds of works. Basically, as long as it's an original work, so someone's had to think, what is this going to be? So a painting, for example, is pretty obviously going to be an original work. And if it's protected by copyright, is it still protected by copyright? If you've got something very old, it may not be. And so then you don't need to worry about the copyright issues anymore. So copyright does last for a long time. I'll give you a warning on that anyway. But for artistic works, it lasts for life of the creator plus 70 years. So if you're featuring a work by someone who, let's say a Georgian painter, let's say you've got a Georgian Regency style shoot that you want to do, then it may be that if you've got an original Georgian print, that's not going to be protected by copyright anymore. You can do what you like with it. You can feature it however you want. If you've got something that is protected by copyright, so something more recent, then you will need to think about what you do with that. Now, the general rule is that an owner, a creator or a rights holder, and they're not always the same person. So a creator can be different from a rights holder. So they have the right to stop you copying. Yeah. So that means publishing, communicating it to the public. So that could also be on the internet. So even if you're not putting it out in a magazine, you're just putting it on your blog or your Instagram or whatever, that would still be communicating to the public. So the creator or rights holder has the right to stop you doing that. But we also have what are called copyright exceptions. And there are several exceptions which may or may not apply to your specific shoot. And this is one of the issues, and I'll be upfront about it, is that I can never give you 100% guarantee that an exception will apply or won't apply. So what we find is that there are some exceptions. So there's one's called incidental inclusion. So if you just had, I don't know, the corner of a painting or something like that, and it's just incidental to the overall image that you're trying to create, then that you don't need permission from the rights holder.
So if my screen here was a shot, and you can just see a tiny, that's actually a birthday card someone gave me, and I framed it because it was lovely. And it's a tiny bit there. That would probably be okay.
Yeah, probably. There's a rule about substantiality, and it's whether it's a substantial part of the work which is being copied. So I can't tell from here what that birthday card is.
Yeah.
So I think probably you'd be fine with incidental inclusion. So that kind of thing, if you're just creating an overall look, there's only a little snippet of a work in there, that may be fine. You don't need permission.
But looking at your room, I can see your painting reasonably clearly, apart from I have got my glasses on. That's very clear that you can see that's a piece of art. If you know that artist, you're probably going to recognize them. That is not okay.
It would be unlikely. That one's out of copyright actually, because it's an Albrecht Dürer. But it's something that you would need to think about. So there are other exceptions which would also be useful. So you could have quotation exception. Now, quotation is a little bit tricky because it doesn't always apply to what you expect it to apply to. But you might be able to, so photographs would not be included in quotation. It's difficult to see how you could quote a photograph if you think about it. That's the reason. But if you had, let's say, a literary work, and maybe you'd stenciled it onto a wall. So you'd stenciled a poem or something like that onto a wall. But you've only used a few words from that poem. Now that may be copyright infringement if it's a substantial part of the work. If it's the most famous bit of the poem, maybe that would be considered substantial. But if you're just quoting a bit and it's just a lovely few words that you wanted to include to give a feeling, then if you acknowledge the creator wherever you would put your acknowledgements for your work, then that should be okay under the quotation exception. So it will just depend case by case what you can use. Sometimes incidental inclusion, quotation might be useful for you. There might be a couple of other copyright exceptions as well, but those are probably the most useful that you would find.
So that's quite interesting. So you see quotes quite a lot, and then you see the name of the person who the quote is from underneath. So that makes it okay because you're crediting that person. So
and that's only for published works. So it has to be like a published poem or whatever it is. But yeah, you would be fine doing that because you've acknowledged where you've sourced that from, essentially, by saying who it's by. And I think that's, you can find comfort in that. It's not that you can't use any copyright protected work. There are things that you can do, and you can obviously arrange your shoot so that it is only featuring a snippet or quoting in that way. If you don't fall within any of those copyright exceptions, and there's loads more guidance on exceptions on our website, by the way, gov.uk. But if you don't think that those apply, then it would be a case of asking for permission. And what have we got? The question was about commercial photography and including art. So I'm assuming it's fine art. So a painting, sculpture, photography.
Say, for example, you're doing a shoot for a sofa company and you want to shoot the sofa with a big piece of art in the background. That piece of art.
Yes. So we're talking a sculpture or a painting or something similar. Okay, good. If you were to do that, you would need to be asking the permission of the rights holder in most cases, because you're using it for a commercial purpose. Okay, you might not be, directly benefiting from featuring that painting or whatever, but it is a commercial process and you would probably need permission. So the way to go about it can vary. If you know the artist or the creator, you could ask their permission. It may be that you've sourced the picture, and I know we'll talk about kind of prop stores and things later, but you may have sourced it from somewhere else, so they may have got permission or they may have contact details. But that would be the way to go about it, and it would be about agreeing terms and conditions, a license, or permission. Those three things are all the same: permission, license, terms and conditions. That's all the same. It's a contractual agreement, basically, that you have permission to use it.
two things I've thought of in all of that. If you wanted to feature a picture, so say you'd been to the Tate Modern and you found a picture of, I'm trying to think of someone who's been dead for over 75 years, an artist who's been dead for 100 years, and there's a print. Can you, so they're famous, it's a recognizable piece of art, but they're dead. How do you know whether you can use that? So could you just put a print up on the wall in a shoot and that you can't assume that's okay, but how would you find out that that's okay?
Yeah, so if the artist has been dead for more than 70 years, you can use their artwork and not have to ask permission.
Right, okay. That's come up recently in, so the other thing is that I have just created a list for the members of, I think there's just over 40 artists now who have said they are happy for us to use their art in commercial and editorial shoots. And I've got them to fill out a form to say, I'm giving you my details because I want you to add me to that list. But I've said in this blog post, you must double check, because someone might come in 3 years' time and the artist no longer wants them, no longer agrees with that. So I've always said, do your due diligence and check. But to have that permission, do you just need it in writing? Do you just need an email that says, I'd like to borrow this, can I use this artwork? And the artist comes back and says, yes, that's them giving you permission. Is that all you need?
So for a license, for permission to use a work, you don't even need anything in writing, in theory.
That makes me nervous.
Exactly, and I thought that probably would. But in theory, you just need their permission, so you can just have an oral agreement. That's fine. So
the fact that they've said, I'm giving you this art, I'm sharing this with you because I want to be shared on sheets. They're essentially, that is an agreement.
Yes.
That makes me twice as nervous because now it's on me.
Yeah. I would always recommend that using copyright works in a business sense, that you always think about copyright. And if that rights holder is alive, or it's less than 70 years after their death, if you're in any doubt, because exceptions only cover very limited things, I would always say get the agreement and have it in writing. But it can just be an email. That's fine.
Well, I think when you're approaching someone, you're going to be saying, I would like to use some of your art. They're going to come back and say, great, how do I get it to you? It's naturally the way it's going to happen, I think. But but for many creators, that is the case. I think that's right. And they want they want to be known, they want to have publicity in a way that they can control to a certain degree. So you should also be very clear about what you're going to do with their work. So when you do have an agreement, it's not just, can I use your work in a photo? It's, can I use it in an editorial shoot? So it's going to appear, or I hope it's going to appear in a magazine or online, or I'd like to use it on my blog, or I will only use this in a published book that I'm working on. So always be clear about what you're going to use the work for, and then that avoids a lot of heartache further down the line, because if you've only agreed to feature it in a photograph, the creator might think, well, it's a personal photograph, there's no danger about that. But if you then start sharing it on social media, and then it gets out of control in terms of people sharing it, and they lose value in their work and their career, then it could be problematic. So I always recommend just being as clear as you possibly can be about what you would like to use it for. Yeah. Some artists and creators may be happy to just do a blanket permission and say you can use it for whatever you like, but always just make sure that you're content, you've done what you need to do. Yeah, you need to kind of make sure you cover your backs, really. Yeah, thank you. Okay, so we touched on this a little. Most of the time we get art from prop houses and they have stickers on that say cleared for usually photography or cleared for TV. We've heard, I'm jumping around now there. Is that enough to trust that that's going to be okay, or do we still have to double check? Because the prop house, I'm not sure the prop house will take responsibility if we use a piece of art. If they say it's cleared, can we be rest assured that it has been cleared? So again, I can't be 100% sure. And what I would say, it's for the user, so you, to be satisfied that you've got the right permission that you need. So if you have used this prop store many times, you're perfectly confident that they've done the checking that they need to for what the sticker says, then fine. It's
something that you can be confident in. If it's someone you've never used before, you might want to check yourself. I would always suggest some degree of caution, because it's you who will be liable and not the prop house.
Yes, yes.
Because the property, the copyright is only one element of the protection. Owning a piece of work does not mean you own the copyright. I mean, that's an obvious point. You guys all know that. But it's worth stating clearly, because in this sort of situation, if you then go on to use that work, you will be liable and not the prop store.
So really, they should all just get art from my list, basically, is what I'm saying.
Possibly comment.
So I think you've really covered this. If you have permission from an artist to use their art in any shoot, is an email enough? Yes, we've already answered that one, sorry. The copyright laws include items of artistic merit, which for us includes furniture and other items that are designed. Could you explain exactly what this means in layman's terms and how it relates to shooting photography? What do we need to get permission to include? So this could be something like an Eames armchair, or a Jonathan Adler. I mean, obviously, if we're getting Jonathan Adler, we're probably going to be borrowing it from the PR for promotion. But if it's commercial and we're just getting it from a prop house or somewhere, so it's not a piece of art. Well, it's not a painting. It's a piece of furniture.
Okay, so I'm going to try and do this in layman's terms, but it's actually quite complex.
Okay.
So copyright protects works of art, as I've already mentioned, so things like paintings and sculpture and so on, but it also protects works of artistic craftsmanship. I can't even say it. Craftsmanship.
Completely got you. Yeah.
So we don't use the term merit, it's artistic craftsmanship. That's the term that's in the law, so that's what we use. Now the question is, what is a work of artistic craftsmanship? And because it's one of these terms which is a little bit uncertain, there have been a few cases in the courts over the years which haven't helped us that much, but they have given us a bit of an indication of what is protected by this. So it still has to be original. So that original test that we talked about at the beginning of the interview is still relevant. So it still has to be original, but it also has to be both, and this will sound a bit obvious, but it has to be both artistic and craftsmanship. So the things that we think it is most likely to apply to are limited edition furniture, jewellery, maybe some ceramics. So we're not talking about sculptures, but some ceramic pieces might fall into this. And I can't be much more definitive even than that. What it has to have is that the person who created it has to show some element of artistic intent and some element of craftsmanship. So that suggests, and I can only say suggest, this is complex. It suggests that mass-produced objects are less likely to be protected by copyright, even if they fell under the artistic bit, because it doesn't have the craftsmanship. So that's why limited editions seem like they might fall within this. So the problem that we face and you face as people working in this sphere is that you can never be 100% sure that something's protected by copyright unless it goes to court.
Yeah.
And obviously you don't want that to happen. So some people will assume that their works are protected by copyright because they think they fall within artistic and craftsmanship. And some people may just kind of on a whim say, well, I think it's protected by copyright because I think it's pretty good. But it may not be. So the key things are, is it original? Is it artistic? And does it have craftsmanship? Those are the three questions to ask yourself. If after you've asked yourself those questions and you think probably yes to all three, you might want to investigate whether it's protected by copyright and get permission to show it. One thing I haven't mentioned at all so far is the fact that there might be other rights. So as well as having copyright, some of those items might have design rights.
Yeah,
so, and trademarks as well. So some of the famous furniture designers have actually got trademarks in their names or signatures. So if you featured the label of the piece, you may actually find that that's protected by a trademark. So one of the things I would advise is, if you're using any of those materials, items, that you think about copyright, but also think, okay, are there any other things I need to worry about? And the reason I say that is because, for example, with trademarks, you also have this idea of passing off, which most people have heard of, but they're not quite sure about. And it basically means that if you were to take a photograph and you had exclusively one person's designs within that photograph as a stylist choice, you might, when you put that out and publish it, it might be that people get confused and they think, oh, you are actually representing that designer. And that designer will say, no, hang on a second, that's nothing to do with me. So you need to just be aware that there are other things which may impact on this as well. But yes, going back to the original point, if you think that the piece you're featuring is original, it's artistic, and it's craftsmanship, then you might want to think about copyright and getting permission to use it and feature it.
So with something like a design classic chair that you might want to put in the corner of a room, how would you go? Like, so we can hire them from prop houses, but how would we go about finding out if we have permission to use them? So say and he's died, but it's trademarked because it's a design classic and it is craftsmanship, and there's probably a number of them, so it is a limited edition. How can you still use that?
Okay, so for the trademark side, there's a trademark register, so you can always check the trademark register, and there are lots of key terms that you could use, like the name, or where if that particular design has a famous like nickname or whatever, you could put those search terms in. So that's again on gov.uk, that trademark register. If you were looking at it from a copyright angle, if you're persuaded that the item is protected by copyright, it's for you to find out who the current rights holder is. Now, again, as it's the same with any copyright work, whether it's a painting or a photograph or a work of artistic craftsmanship. So you go through a process. We have published some guidance called Diligent Search Guidance. Now, this was really originally published for our Orphan Works licensing scheme, which I run, which I'll come back to because that will be relevant. But it's sources to help you find rights holders. And in this instance, you'd probably use the Visual Art Diligent Search Guidance, which gives you a whole series of places to check. So there are collective management organisations, or also known as collecting societies. There are suggestions about archives to check, certain databases that you can check, and you can just go through them and find out. For someone who's died, now for someone famous, it's probably easier to find out who has inherited the rights or who looks after them, because it's probably quite an active estate. But if you found like this amazing piece that you wanted to feature and they weren't a famous person and they had died, you'd established at least that, you can check the probate records because copyright is inherited. So if you check the will, they may have left their copyright works to someone specific, although most people don't specify copyright in their will. So it just forms part of the whole estate. So if I had designed a sculpture, let's say, and created that, and I wanted to ensure the copyright went to someone specific, I'd put that in my will. But otherwise, it would just be part of my estate. And if that was split between 3 children, say, then the 3 children would have an equal say in what happens to the copyright works after my death. Right. So that's how it works in terms of trying to track down who gives permission.
I'm trying really hard not to go too deep. So if someone has died and the copyright has been passed on to children or whatever, once 75 years after that person has died, that copyright will expire even though they've handed it down to their family, yeah?
Yes, 70 years, not 75.
70, I'm adding.
Yeah, don't add any more.
Oh, that's plenty. And one other question about this. So
I should also say, though, I think just for a little bit of clarity, that some designers and others work for someone when they do their designs.
Yes.
And even though they become famous for those designs later, the original designs may belong to their employer. So just for clarity's sake, check whether they were working for someone else when they designed that object, or when they painted that painting or whatever, just so that you know the place to start for looking for who the owner is. So the creator and the rights holder are not always the same.
Yeah, sounds a bit like how magazines hold the rights to images that you take with photographers and all that. Yeah. Just looping back, one more thing about the furniture. I think that if you're getting hold of a piece of furniture to shoot in a commercial photo shoot that's going to be used for a brochure or advertising or whatever, it's one thing. But if you are shooting someone's house, so you're going to do a real home shoot for a magazine, and they have these design classics in the house, that's not your house, and you're shooting it as a representation of their style. And it's not all one designer, it's going to be lots of different people, or so they've got one swan chair or something. Is that affected?
So no, you, as I said, the ownership of the object is completely separate from the copyright. So you would still need to think about, okay, are there any copyright protected works in here? Are they original? Are they artistic? Are they crafts? Do they show craftsmanship? Are there any paintings, photographs? And then you go through the process about, you know, how much am I featuring? Do I need to get permission? If I do need to get permission, where do I start? So yeah, it can feel like a really long process, but it will actually be quite quick. It's just making sure you've gone through those steps to think about it.
Yeah. Okay. I don't think people realise that. I didn't realise that. We might have to skip some questions because we're going into a lot of detail, which is great. Right, this is a little bit different. If you want to share a piece of work that you have styled, so if you've got an image that you've had featured in a magazine, if you want to share it on social media, are you in breach of copyright if you take a picture of the magazine with your phone and then post it to Instagram or social media? This person said, I've heard that there are rules about crediting the image and that the magazine within the photo, you should only, it's like you were saying earlier, you should only show a certain percentage of the image in the magazine. Is that correct?
So there's a myth about percentages. So forget about percentages.
Oh, okay.
Don't think about them. What you have to think about are you able to rely on a copyright exception? So for Instagram, Facebook, Twitter, are you, okay, so the person, just trying to get my head in order, sorry.
That's okay. I think I know where you're going to come from. It's kind of like you want to say, I styled this shoot, it's in this magazine, and you're promoting it to help make sales.
Yeah.
So you don't have the copyright, you're using your own image, but the image is of another image that is copyrighted.
That's right. So it's basically almost the same process as you go through when you're doing the original shoot for your stylist role. And I think what you need to think about is, okay, so what am I showing in this image on Instagram, whatever? Is it just a tiny bit of the magazine? Is it a quotation? It could potentially be a quotation. Is it for, there's another exception for criticism and review. So if you took a photo and posted it and said some kind of critical review of the magazine, that might apply. But basically, the issue will be what the magazine is kind of interested in. So if they're only interested in sales and you are helping them with sales, they may not worry about the copyright, but it's down to them to challenge you if they feel that you are infringing copyright. So if the photo that you took was of a double page spread, which was just your work, they may be happy with that if that kind of generates some additional sales. If it was a kind of collage page which had photos from several different stylists and you'd featured plenty of them, then they would also have an interest in saying, well, hang on a second, I didn't give you permission to repost all of that. The thing with social media is you also have to be aware of the terms and conditions of the site. And because when you share something onto Facebook, Instagram, Twitter, whatever platform that you use, there will be certain standard conditions about what can happen to that. And it can start to be shared more freely. Now, again, the rights holder, so the magazine in this case, might be happy with that, but they may not. So really, I would just kind of take time to understand what your relationship is with the magazine, and before you even think about doing it, and then think, okay, well, it's, you know, it's a very small snippet of the magazine, it should be fine. Yeah, it's again, it'll be a case of thinking about whether an exception applies or whether you need to actually get permission.
Yeah, and I think in general, I think magazines want you to be sharing your work because it's saying, oh, I did this shoot and look, and I've seen some people do this really well. They literally go, oh, here's my shoot here, and oh, and there's a really great, and they don't show the whole feature. They're just flicking through really quickly and then pointing out, like I do it quite a lot. I share the members when I've got a magazine, I go, oh, look, this is full of the members, and I flick through. But I don't show too much because I kind of want to whet people's appetite. But it's usually on stories, so it's there, and then in 24 hours it's gone. But I mean, obviously Instagram, Facebook will probably still have it somewhere and can reuse it anyway. But yeah, so it's quite, I quite often see people when they show their work very slowly, and I do think, oh, you're just showing everyone, no one needs to buy it because you've just shown every page that you've done. And if I was a magazine, I wouldn't be very happy with that. But I think I might have to get in touch with some magazine editors and get some.
Yeah, it's probably a good question to ask them actually, because they'll have a much better feel for what they're happy with and not happy with.
Yeah, put that on my to-do list.
Yeah.
Thank you. So I think we just answered that one. Right, this is relating to this picture here actually. Am I right in thinking that items like greeting cards and decorative gift wrap don't have copyright issues in the same way that art does? When I worked on TV set design, I was told to use these in frames to avoid copyright issues. Can you use postcards and...
They are artistic works.
That's what I thought, which is why I put it in a frame.
Yeah.
You do have to get permission.
So, yeah, I think... it sounds ridiculous, I know, because some can feel like they're very generic.
Yeah, no, I don't think it does though. I think I've got artist friends who I've put on this list, and I would never just take for granted that I can use their work because I know the hours that go into for them to do that. So,
yeah, again, with particularly with greetings cards and things, if they're from a big company, it may be that the company owns the copyright in them, but you know, you will often get artists who, you know, create their own gift cards, greetings cards, because that's part of their again, part of their way of becoming better known. And I would still ask permission if you were featuring, you know, a significant amount of the card. Gift wrap is probably a little bit different because it's so repetitive. So it's, I guess you could say that the original design for the gift wrap is protected. But yeah, it's a little bit more of a difficult issue. I wouldn't want to give you a definitive answer on gift wrap, but I think greetings cards in particular, think of them as a artistic work, and it may be that you can quite easily get permission to use them actually, but yeah, I would always think of them as an artistic work.
Thank you. A lot of clients worry about books on a coffee table in a shot. So like if you can see the title is visible and the whole of the top of the cover. How much of books or magazines can we show in a shoot?
So yeah, I mean, books, as I mentioned before, are literary works, so they are protected by copyright. And what you will need to remember is that many books, obviously most, will have some kind of artistic work as their cover. So there are issues to think about. If you've just got a pile of books with just the title showing, for example, it's unlikely that that would breach copyright. Because it's quite unlikely, it's possible, but it's quite unlikely that the title itself would be protected as a literary work. It's what's inside is protected. Magazines, again, it's a bit different because they're so visual and they're likely to have more in the way of artistic works featured on them. I don't just mean kind of glossies, but, you know, kind of art magazines and things like that. They, independent magazines, they will probably spend a lot of time choosing what goes on their cover and would want that to be protected in the main. So again, it will just depend how much you're showing. As I say, if it's a pile of books, it's unlikely to be a problem. But the one that's on top, you might want to think a bit more carefully about. So you might want to stack them in a certain way.
Yeah, just something on top. A cup of tea or a bowl of fruit or something. Okay, we've answered that one. We're kind of covering quite a few bits and pieces as we go. What if we share an image on my blog or social media where I have permission to share the actual photo, but it might contain a Warhol print or an Eames chair, especially if used on a client's blog? I think we've answered this actually. So if I'm writing a blog post for a retailer on new trends and I'm using an image that has these pieces in, am I in breach of copyright? So I think there's two questions here almost. If you've got, well, if you're getting an image from a PR, then you've got permission to use that image. But if you're getting an image from someone and you've got these pieces in it, can you reshare that?
Again, I think, yeah, it's similar to what we've said already. It will depend how you're using it. And if you were just putting it, you know, simply on the blog as it is, you may want to think about getting permission because it's unlikely to fall within a copyright exception. But, you know, again, it may well be down to what the rights holders care about. And it may be that they're happy for it to be just on a simple blog, whereas they might object to it being on social media. So, you know, you have to, again, it's kind of what I said earlier, but about being clear about what you're asking permission for as well.
Yeah.
But yeah, you might want to select a photo which has fewer works featured in it, but still representative of what you're doing, rather than more works where you might have to get permission. But yeah.
If you contact someone and say, I would like to use this image from your website, and then you put it onto a blog post for, so you're paid to write a blog post for an external brand, you've got permission to use that image. You're still responsible for whatever's in that image.
So yes, basically, because who knows whether that person had the permission originally to include those works. So if they can tell you, I've already got permission from Andy Warhol's estate and what was the other thing, Eames chair, I've already got permission from Vitra to use this, so it's fine, you can use it, I don't mind, and you're confident in that, then that's okay. But if you have any doubt that they have the permission of the original things and you think they would need permission if you were taking a new image like that, then I would go for permission.
Yeah. So this one is the one that I was referring to earlier about a written feature, and it's quite a specific thing, but I think it's quite interesting, the whole topic of it. So if we can answer the question without having to go to any specifics. A written feature of mine has been copied onto the website of a well-known entertainment company without my permission and with no byline. I believe it's been sitting there for 4 to 5 years. Am I entitled to payment, compensation, and if so, how do I go about asking for it? So this is the written, you've kind of answered this question before you've even started, but this is written, this is quotation essentially, is it not?
Well, so what I would say is it looks like, well, it's not 100% clear from the question. If the whole feature has been copied onto the website or a substantial part has been copied onto the website, then that would potentially be copyright infringement. They would only be able to rely on the quotation exception or some of the other exceptions if they had acknowledged where it was from. And if there's no byline, they haven't acknowledged where it's from. So they wouldn't be able to rely necessarily on that particular exception, the quotation exception. There may be something else that applies, but on that particular one. So I think, you know, the fact that it's been sitting there for a long time is probably will make it harder to track down who it was originally. But no, it doesn't mean that you can't take action now. So what we would always suggest is that if you believe your copyright is being infringed, that you start the process informally. So it'd be contact a website and ask them to take it down as a first instance. And then you can negotiate about how much you want to charge them for a license fee, because that's what you would have done. If you are not successful with that, the informal process fails, essentially. You could try something like mediation. And the IPO where I work has a mediation service, including for copyright disputes. So but both parties have to agree to mediation. So if the other party is still being difficult, putting up barriers, then you can take it to court. Now, copyright infringement is, generally speaking, a civil infringement. So you would go to the civil courts. Now, for intellectual property, we have a specific court. It's called the Intellectual Property Enterprise Court, and it has a small claims track. And so you can go there and you can say, lodge your infringement claim there and say how much you want for your license, and it can go through the process. If it were a really big claim, it would go to the High Court. People sometimes are aware that copyright infringement can be a criminal offence, but it's only criminal if it really kind of meets quite a high threshold, and there's usually quite an element of commercial exploitation that's been going on in order to make it a criminal infringement. So it's most likely to be a civil infringement. You can take the infringement to the court yourself. You can represent yourself, be a litigant in person, and there's guidance to help you do that. Or you can obviously engage a legal advisor, a solicitor at any stage of the process to help you with the negotiations if they are responsive, or taking it to court.
So if this person, this is an actual writer, so this is their living, and this website has used her copyrighted writing without permission, so can she get can she demand a fee for having used it for 4 or 5 years without permission?
Yes.
Yeah, so she can,
a license fee, essentially.
Right, I see. Okay, right, I didn't realize that was what that meant.
Yeah, so it's basically you can ask them to take it down, and you can charge them for the back license fee that you would have had. And if you're happy for them to continue having it up, as long as it acknowledges you, then you can agree a future licensing fee as well. But yeah, it's that's what you're really claiming. You're claiming your lost income for the use of that work.
Yeah. Okay. Brilliant. Thank you. I wasn't expecting that to be the answer. That was very good. Right. Long one. It would be really good to understand all of this better. This was in the middle of a conversation I was having with a stylist. There's a wording that says something along the lines of items used that are secondary to the main. I think this comes into the percentage thing we were talking about. Items used that are secondary to the main focus of the image are exempt, but there seems no guidance on what the definition of secondary items are. For example, if I buy some plates that are clearly from H&M or IKEA, for example, and they are stacked in the back of a cake shot, is that okay? Because they're not the main focus.
So
this stylist actually, she does a lot of prop styling. She does a lot of food, and she had an image of, I can't remember what it was now. It was something to do with music, and she had a piece of music in the shot, and we were talking about whether that image, that piece of music is copyrighted and whether that's okay to put in. So it's kind of a twofold question: whether recognizable plates in the background is okay as a secondary item, and whether you can use something like, I think that might come into the whole like a magazine sort of thing, but you've got a piece of writing, a piece of music with the name of the composer and everything on there as well, quite clearly in shot so you can read it. Is that okay? So
the first bit of the question is about secondary to the main focus. Don't use that expression. We are talking about incidental inclusion. So I've already mentioned that if you're only showing a small part, or it's very incidental to the whole shot, then it's unlikely to require copyright permission because it comes under incidental inclusion. There's no percentage rule. People get this idea that you can show a percentage, but there isn't. It will be case by case what is considered substantial of that work. So that's part one. Part two, is about plates from a certain store and stacking them. So that goes back to our question about artistic craftsmanship. So I said that ceramics could be works of artistic craftsmanship.
Yeah.
Are they artistic? Maybe. Are they craftsmanship? Well, they're mass produced. So that reduces the likelihood that they're protected by copyright. It doesn't remove the possibility altogether, but it does give a suggestion that they will not be protected by copyright. So they shouldn't be a copyright issue if they're just stacked up as the suggestion is. Then you've asked about the piece of music. Now, musical works are protected by copyright as well. And so if it's clearly visible and it's a substantial part of the music, and another copyright exception does not apply, then yes, you would need to get permission to feature that music as an image, essentially, in your shot. So yeah, those are kind of the three areas of that question I would go for. So one is incidental inclusion. There's no definition, there's no percentage, but it's about common sense and reasonableness as well. So you need to just kind of apply some common sense to that. The plates, if they're mass-produced plates, even if they're recognizable, it's unlikely that they're protected by copyright, but it's not impossible. And then with the musical, the song that or the piece of music that you mentioned, again, if it's a substantial part, then you might need to think about getting permission.
And if that composer had died 100 years ago, if it was Beethoven or Mozart or someone, we can assume that he's been dead more than 70 years. So
I didn't want to get into the complicated bit, but you've made me.
Sorry.
No, you're right in the sense that if it's over 70 years since the person died, since the creator died, then it's no longer protected. However, recent editions are protected for the publisher, because publishers still need to make money even if they're printing Beethoven or Mozart today. So they have a special protection of what's called the typographical arrangement, which is basically how the music looks on the page. And that's protected for 25 years from publication. So if you're using a torn and folded piece of music that comes from 1883 and it's Beethoven, then no, there won't be any protections left in that and you can use it. If you're using a modern edition, from 2010, published by a recent publisher, then they will have an interest in the featuring of that music.
Yes. So she was right to remove it.
Or just find an older version of it. That's
or just go to boot sales and get really old pieces. More excuses to shop.
Yeah.
Last question. My brain is like whirring now. I've got so many things in my brain. It's been brilliant. You've answered so many questions and made it so clear. Okay, this one I think was the most asked question. Is indemnity insurance worth it? Will it protect me or my business from personal liability? Should interior stylists have insurance to cover themselves in case they are in breach of copyright law? So really, I've asked you lots of questions there that are not relevant to copyright, but the one is, if we have indemnity insurance, or if we have insurance to cover us if we use something that is copyrighted by accident, are you able to say whether that is a good idea or not? Okay. I've put you in a very difficult position there, so apologies if I have.
No, it's okay. It's not a difficult position in some ways, because basically I can't say so copyright infringement is copyright infringement. If you're found to be liable, you are personally liable. It's only that your insurers may pay the costs. So that's how insurance works, essentially.
Yeah.
So they may cover you for copyright infringement. It may be in your policy, and that's fine. So it means that you are protected financially from that happening, but that doesn't remove your personal liability as such. Mm-hmm. So you would still have the case brought against you. It's just your insurer would wrap it up.
Yeah.
If they were happy that you'd done all the right things.
I was going to say, from what you've been saying, we kind of now have the tools to go and check what we need to check. We know exactly what we need to be, we can say, well, we got permission from this person and we looked on this list and we believed that was okay. So we've done our research. So
absolutely. So I think, you know, insurance can be a great thing. And that's probably more a question for you in some ways. You know, should people have insurance? You know, I don't know. If for your profession, it would be, yeah, okay, good. Yes, is the answer.
Well, you should have insurance anyway. And it's, sorry, I'm just going to say this now so anyone watching or listening later to the podcast will know this. I did a lot of research into whether you need insurance or not. There is a resources page that's open to everybody. It's not just for members on the website about what the different insurances are and explaining them. When I went to get insurance, when I realized that actually I hire assistants and I want to know that my assistants are covered, because even if I'm doing a job for a client, that client is not responsible for my assistant. I have to make sure they're okay. So if they break their leg or they break a vase, I am covered. But I wanted to cover the website and my styling work. But when I phoned them and spoke to them specifically saying, I want to make sure it says I have copyright, like insurance against copyright infringement in my contract. I didn't want it to brush off. I said, I need it in writing, because when this all kind of became very, very prominent within the industry, I got very nervous, and I just thought it's really important to make sure you're covered. Also, the other thing is that a lot of stylists don't have contracts. I don't have a contract. It's on my list, but a lot of people, when they are hired to do shoots, are asked to sign a contract with their client that says, I personally, as the stylist, will take responsibility for any copyrighted product. So they are literally putting all the pressure onto you. So I wanted to know I have the insurance lined up in case anything happens, but I'm doubly careful. And that is a lot of why I started this artist list, so that I could find that I knew was completely okay. But it's all the other things, all the furniture and things as well.
Yeah. So there's one thing I wanted to add, which is kind of related to what you were just saying, which is if you have gone through the process of trying to find the rights holder, you can't find them, and you still really, really want to use that work, we do have the Orphan Works licensing scheme, which I mentioned before, which has the diligent search guidance. And you can come to us and say, I want to use this piece in an editorial piece, and we will quote you a price to do that if we're satisfied that you've done the right diligent search. So that is a way to avoid liability. So insurance will cover you potentially, but we will also provide you with actual protection from liability. So for the length of your license, which can be for up to 7 years, you can actually be sure that even if the rights holder comes forward, you don't have to do anything. You don't have to take any information down. You can just let us deal with it and pay the money, the license fee, to the rights holder. So there are ways for you to kind of operate. So the first, I kind of want to wrap it up in a way to say, when you're using a work, and you've gone through the process of thinking, yes, it's protected by copyright, or I think it probably is protected by copyright. Is it still protected by copyright? Is it still within the term? So life plus 70. That's the first question. Second question, if it is still protected by copyright, can I use an exception? Third question is, if I can't use an exception, I should get permission. Can I find the rights holder? Yes, then you go off and do that. If you can't find the rights holder, you can try and get a license from us, from the Orphan Works licensing scheme. So, you know, there are 4 steps to go through, and it won't always require you to do lots of work, because sometimes the item won't be protected by copyright anymore. So you can just go ahead and use it.
That is a nutshell. Very good. Thank you. That's been brilliant. We haven't had any questions coming in because I think you've answered everything, and you've answered in a lot of depth. So thank you so much. Also, I understood all of that, which was brilliant, because sometimes the language can get really confusing, and we're intelligent people, but it can get a bit overwhelming, and you've made it really clear. So thank you so much for your time. Thank you for answering all these questions. There was a lot of questions there. We've done it in an hour, so that was pretty good. Well done. Thank you, Margaret. It's been absolutely fabulous to have you on. I really appreciate your time.
Not at all. And good luck to everyone. And if you do have further questions, try gov.uk first. There's lots of information on there. And then you can always be directed to ask questions to the IPO, info@ipo.gov.uk.
Brilliant. Thank you. I will link those up above in a second. Brilliant. Thank you. Thank you so much.
Thanks for listening to the Inside Stylist podcast. You can find all the details from today's episode over in the show notes on insidestylist.com. If you enjoyed the show, I'd love it if you would head on over to iTunes and rate and review it. It's the best way to help other people find the show, and I'd really appreciate it. Until next time, bye for now.